4, and today we are going to present the Ward versus Tesco Ltd 1976. This case is about negligence and occupiers liability. It involved a customer who accidentally slipped on a yogurt in a supermarket. We will now recall the accidents, explain the law, and analyze the judgments. Let's go! This is recall the accidents. Mrs. Ward was shopping normally inside the defendant's supermarket until she slipped on a pink cartoon yogurt substance that has been spilled all over the defendant's supermarket floor, and there was no evidence on how long the yogurt had been there. It is important to note that Mrs. Ward did not see the yogurt before she fell, and she only aware of the spillage that has been occurred after the accident. This explains why the plaintiff could not provide the evidence on how long the spillage has been there. And due to this case focus on whether this case is only lack of the plaintiff evidence to support her claim. Despite this, the trial judge held that the prima facie case is being established. The test code applied. We will now be explained the legal issue by BASHIRA. This appeal raised a crucial legal issue. When a customer slips on a hazard in a supermarket, must the customer prove how long the accidents occur? Or is it sufficient for them to show the accident occurred under the occupier's control? This question lies at the heart of Ward v. Tesco.
So, what is the legal issue? The legal issue is simple. Does the plaintiff need to prove how long the spillage was on the floor? The answer is no. This is because the supermarket have frequent of spillages, and the customer are not expected to shop like detective. So, the court applied res ipsa locuta, meaning the accident itself allows the inference of negligence. Once a hazard causes injury, the prima facie negligence is established. So, the burden of proof shifts to the defendant. In simple terms, res ipsa locuta helps plaintiff where direct evidence is unavailable. This doctrine recognizes that some accident would not normally occur without the negligence. In a self-service supermarket, spillage are known risks that occupiers must actively manage.
Tesco argued that they had a cleaning system. The staff were instructed to deal with spillages. The floor were cleaned regularly. But the court said having a system is not enough. Tesco failed to show when the floor was last inspected or cleaned. There was no proof the system worked at the major time. Because of this gap, Tesco failed to review the inference of negligence.
The Court of Appeal held that the plaintiff did not need to prove the duration of the spillage. Once prima facie negligence was established, the burden shifted to the Tesco. Tesco failed to prove that its cleaning system was effectively implemented at the time of the accident. Accordingly, the appeal was dismissed. The standard of care required of occupiers is one of reasonableness. However, reasonableness must be supported by evidence. A system that only exists in theory cannot protect an occupier from liability. Our elder dissented. He argued that the accident could occur even with reasonable care. However, the majority rejected this view. This case is significant because it is the burden on plaintiff and it strengthens the occupier liability.
This case has practical implications for supermarkets and shopping malls.
Occupiers must keep inspection records and ensure customer compliance.
Otherwise, there is liability even when accident appear minor.
So, in conclusion, Ward versus Tesco shows that occupiers must not only have safety systems, but must prove that those systems are effectively operating.
Failure to do so result in liability. Case closed.